Hi, good afternoon, everyone, and thank you for joining us today. My name is Ana Maria Studer. I'm the Advocacy Support Program Manager here at Standpoint. Just to let you know, this webinar is being recorded, and the link to the recording will be emailed out to the Standpoint Legal Advocacy listserv, and it also will be added to our YouTube channel and website later on. For today's presentation, I have put in the chat box, actually I haven't, but I will put in the chat box the link for the PowerPoint. So that will be easier for all of you to follow up along. My role today is going to be to facilitate the webinar. If you have any questions during the presentation, please type your question in the Q&A tab or in the chat box, and I will pass it along to Kelly. Most of you probably already know about Standpoint, but for those of you that will listen to this webinar later, or for those of you that don't know, Standpoint is a statewide organization. We are a team of attorneys and advocates working to assist individuals who have experienced domestic violence, sexual violence, and trafficking if they have experienced domestic violence or sexual violence. We also provide assistance to system professionals who work with survivors, and we do this by facilitating trainings and answering calls to our action line. These trainings are the new laws training that we do throughout the whole state of Minnesota every year, the monthly webinars for advocates like the one we're presenting today, and other trainings by request. Our action line, it's answered Monday to Friday from 9 a.m. to 4 p.m. and it's through our action line that the team of attorneys and advocates provide services. Our attorneys provide legal advice to the survivors, and the advocates connect callers with resources, safety planning. We listen and help callers identify possible options and next steps to take. Our webinar today is about employment law. Our presenter is Kelly Jeanetta, and she has been practicing law for more than 25 years. She graduated cum laude from William Mitchell College of Law. She has her own firm since 2012. Ms. Jeanetta represents individuals who have experienced discrimination and retaliation in employment, and she also provides advice and counsel on employment contracts. She handles union grievance arbitrations and undertakes administrative appeals of long-term disability benefits denials. Ms. Jeanetta was one of the Minnesota Lawyer Attorney of the Year for 2020. In 2019, she received the Carla Wall Dedicated Advocacy Award. Ms. Jeanetta has for many years been recognized as a Minnesota super lawyer, and she is past chair of the Governing Council of the Minnesota State Bar Association Labor and Employment section of the, and past president of the Minnesota chapter of the National Employment Lawyers Association. She was an adjunct professor at Mitchell-Hamley School of Law, what it used to be the William Mitchell College of Law, from 2014 to 2022. She's certified by the Minnesota State Bar Association as a labor and employment specialist. And Ms. Jeanetta has also been a volunteer with the Volunteer Lawyers Network for 10 years. Now let's welcome Kelly, and thank you so much for being here with us today. Now you take over with the webinar.
Thank you. I really appreciate the opportunity to speak to you about employment law. It's something that's near and dear to my heart. I've been, as Ana Maria said, I've been doing this for more than 25 years, and I've had a variety of different experiences with labor and employment law matters. I do quite a bit of state court and federal court litigation, and I also get involved helping individuals with their EEOC charges, charges with the Minnesota Department of Human Rights, and even charges with the National Labor Relations Board. And so it's always kind of a moving target, a changing landscape, and I'm hoping that I can just kind of give you some basics about employment law, and then I'm going to talk more specifically about sexual harassment. I think we'll spend most of the time talking about sexual harassment, and I do welcome your questions. There is a chat spot there. You can go ahead and put your question in as we go along, and Ana Maria will interrupt me, and I'm perfectly happy for her to do that. The question can be asked as we go along. I want to keep this, relatively informal. I don't want to save everything up and, do questions at the end, although we can do questions at the end as well. But if you have a question, please feel free to ask it, and don't feel like you have to hold off till the end. So all right, well, I'm going to move along to the next slide. The first thing, and I apologize if, some of you already know this, if this is just a little bit too basic, but I talk to a lot of people on a daily basis, potential clients, people that I'm connecting with through various volunteer programs, and even other lawyers who are not familiar necessarily with the employment at will concept. In Minnesota, as is the case with most states, employment is at will. So what that means is that an employer is free to discipline or terminate an employee for any reason at any time. It doesn't have to be a fair reason. And this is where a lot of the confusion comes into play, because people will rightfully think, well, hold on here, the reason that I was let go or the reason that I was disciplined is not fair. And it doesn't matter. It doesn't matter if the reason is unfair or not. Unfairness, if that's a word, does not translate into illegal. There are some exceptions, of course. An employer may not discriminate against an employee, may not terminate or otherwise discipline an employee for reasons that are illegal under state and or federal law. And some illegal reasons for discipline or termination would be if the employee is being targeted because of their protected class or because of their protected activity. And so, some of those protected classes include race, national origin, gender, sexual orientation, status as a disabled person, religion, and there are prohibitions, of course, under state and federal law that prohibit an employer from retaliating against employees who report discrimination based on those categories. And there are some other things that we'll go through as well that are illegal. But for now, suffice it to say that generally speaking, an employer may discipline or fire an employee for any reason, unless it is a reason that is made illegal under state or federal law. In some cases, there are some federal employees have greater protections than private employers do, or private employees, I should say. In some federal employment situations, they have essentially baked into their system a just cause provision. And that is the same thing that is present in bargaining units. So if an employee is a member of a union, if they're part of a bargaining unit as part of their employment, they are, generally speaking, entitled to the benefits of just cause termination or just cause discipline. So that means that if you're a union employee, or in some cases a federal employee, you can't be terminated unless there's just cause for that termination. You can't be disciplined unless there's just cause for that discipline. And just cause is just another way of saying fairness. So again, generally speaking, employers may discipline or fire employees for reasons that are unfair unless they're part of a bargaining unit or a federal employee. So that's just sort of a general basic landscape that I wanted to get out of the way. Just remember, unfair behaviors, unfair reasons for termination and discipline do not necessarily translate into illegal. All right. So what is illegal? What is illegal employment discrimination under federal law? And I want to talk about federal law first. So Title VII of the Civil Rights Act was enacted in 1964. That legislation made it unlawful for an employer that has 15 or more employees to discriminate against an individual because of race, color, religion, sex, and national origin. That 15 or more employees is important. There are many, many employers who have 1 or 2 or 3 employees, 10 employees even. They don't have that requisite 15. If they don't have 15 employees, they're not regulated by federal law. Now, one of the slides that you'll see in just a minute is a slide having to do with discrimination under the Minnesota Human Rights Act. And under the Minnesota Human Rights Act, to be an employer regulated by that act, the employer only needs to have 1 employee. And so in some cases, an employee may not be entitled to the benefits of the protections provided by federal law, but he or she or they will be provided the protections under state law. So one or both of those laws will apply to employees here in Minnesota. Now, the Americans with Disabilities Act was not enacted until 1990. It was later amended in 2008. It gives protections for individuals who are qualified individuals with a disability. And there's a lot of analysis that goes into determining whether or not somebody is a qualified individual with a disability. We'll talk about that a little bit, but it gets complicated. And fortunately, with the passage of the Americans with Disabilities Amendment Act, it is a lot easier for individuals to demonstrate that they're disabled under the law than it was before. Now, all kinds of systemic and neurologic and muscular sorts of impairments and mental health issues are all considered to be disabilities under the law. The Age Discrimination in Employment Act was enacted in 1967. That makes it unfair and illegal for an employer to discriminate against employees who are age 40 and over. One caveat there is the employer has to have 20 or more employees to be regulated by federal law. But again, for employees in Minnesota, the Minnesota Human Rights Act only requires 1 employee for an employer to be regulated by state law. And the Minnesota Human Rights Act covers all of these things you're seeing on your screen. So it covers race, it covers color, religion, sex, national origin, it covers disability, it covers age, and it also expressly covers sexual orientation, which is not something that federal law does. Federal law has never expressly covered sexual orientation, whereas the Minnesota Human Rights Act has and does. Over the last many years, case law has developed to recognize that sexual orientation is protected under Title VII based on sex. But unlike the Minnesota Human Rights Act, there was question about that for a long time, and that was because the law, Title VII, did not expressly prohibit discrimination based on sexual orientation, whereas the Minnesota Human Rights Act did. Minnesota has been kind of at the vanguard of a lot of things with respect to protecting employees in the state of Minnesota. And I'll get to that in a little bit, but so under the Minnesota Human Rights Act, and I've already touched on this, it covers a broad array of protected classes. So again, the sex, marital status, I didn't talk about that, race, color, creed, religion, national origin, and then there's the sexual orientation, age, and disability. There's, again, only one employee is necessary in order for employers to be covered by our Minnesota Human Rights Act. Now, what I was starting to talk about a moment ago about how Minnesota has been kind of on the cutting edge of protections for our employees here in the state. So in 1969, the Minnesota Human Rights Act was amended to prohibit discrimination on the basis of sex. Believe it or not, prior to 1969, it did not prohibit sexual discrimination. But in 1969, it was amended to do that. It did not, however, expressly prohibit sexual harassment. But then in 1980, our Minnesota courts recognized that sexual harassment was a form of sexual discrimination. And from that point on, sexual harassment became illegal in the state of Minnesota. And that was pursuant to the case Continental Can versus State. And then in 1982, 2 years later, our state legislature essentially baked in or, expressly made sexual harassment a part of sexual discrimination prohibited by the Minnesota Human Rights Act. Amazingly, federal law still does not expressly prohibit sexual harassment. Title VII, does prohibit sex discrimination, but the statute itself still does not expressly prohibit sexual harassment. Now, I think it would be nice if it did. It's not entirely necessary that it does, because in 1986, federal case law recognized, by virtue of the Meritor Savings Bank case in 1986, recognized that sexual harassment could affect the terms, conditions, and privileges of employment. And so therefore, sexual harassment was something that was recognized as a form of sex discrimination. And it's amazing to think that, in 1986, the courts were just saying, oh, gee, yeah, I guess sexual harassment could affect, people's terms, conditions, and privileges of employment. It's amazing to think that was even a question, but it was. So Minnesota is a little bit ahead of its time. I want to get into some, dig down a little bit deeper with respect to, what constitutes a sexual harassment or hostile work environment under federal law. And there's a lot to talk about here, a lot to unpack. And again, Minnesota is ahead of federal law on this subject. And I'll talk about that in detail. And it's something near and dear to my heart, because I partnered with an attorney by the name of Jerry Laurie. He's an attorney here in the Twin Cities. He's retired now, but he and I took a case up to the Minnesota Supreme Court a couple of years ago in 2020, I think it was. And got the case here. I'm pretty sure it was 2020. But it was the Kenna versus Homeward Bound case, and we'll talk about that case. But that's a big deal of a case, because in Kenna, the Supreme Court, the Minnesota Supreme Court, one of the most important things that the Minnesota Supreme Court did in that Kenna case was to say that for cases that arise under state law, under the Minnesota Human Rights Act, federal precedent does not have to be followed with respect to determining whether or not the sexual harassment was severe or pervasive. And the reason that's important is because under federal law, and until 2020 under state law, well, actually it's still the law, but it's just viewed differently now. in order for an employee to demonstrate that she or he suffered sexual harassment or a hostile work environment on account of sex, they had to demonstrate that the harassment was severe or pervasive. And that bar was so high. And it still is so high under federal law. And I'm going to talk to you about some cases that demonstrate just how high a bar that is. I mean, but essentially the bottom line is that, and I've said it here in the slide, not every insult or ridicule gives rise to a claim of illegal sexual harassment or hostile work environment. The harassment has to be unwelcome, which, that's not a terribly high bar. It has to have affected a term, condition, or privilege of the individual's employment. It has to have been based on the employee's protected class. So this is just, this is generally speaking what a hostile work environment claim would look like. It could be somebody is subjected to a hostile work environment based on something other than their sex. It could be maybe based on race. If they were targeted because of their race, that could constitute a hostile work environment under the law. But the big takeaway is that with respect to sexual harassment, it's got to be significant. It has to be severe or pervasive. And under federal law, severe is severe. An assault has been deemed by the federal court to constitute severe behavior. But something less than assault, a touching, and I've got examples of cases where, in the Kenna case, even, for example, the coworker who was the harasser, touched her, said extremely disgusting things to her, and the court originally said, no, that does not constitute sexual harassment because it wasn't severe or pervasive. And for purposes of analyzing whether it was pervasive, courts were saying, and the federal courts are still saying, that it has to be basically happening all the time. So if somebody is subjected to behavior, that's gross and disgusting 1 week, and then a couple of weeks go by, and maybe a month goes by and something else happens, and then maybe another month goes by and something else happens, maybe there's 3, 4, 5 things. It's very possible that under federal law the court would say that's not pervasive. And unless there's a significant touching, not just touching the shoulders, not just a hug, not just touching somebody's hands, it has to be something like grabbing the breasts, grabbing the butt, something that is more along the lines of an assault for the federal court to construe that as severe. So that's the federal law in terms of sexual harassment. A couple of cases that I just wanted to highlight that we argued in the Kenna case, and that I think went a long way towards demonstrating for our Minnesota Supreme Court how ridiculous this was getting. So there was this Duncan case, a federal court case, where the supervisor had a planter in his office that was shaped like a man, with a hole in his pants, in the front of his pants, and then a cactus protruded from that hole in the pants, so like a penis. And he would show this to Duncan, Ms. Duncan, who was his subordinate, on a regular basis. He thought it was, something to be proud of, apparently. He kept a pacifier, a child's pacifier, in his office that was in the shape of a penis, and he would bring it out on a fairly regular basis and show it to her and talk about it. He directed her, Ms. Duncan, to draw a picture of this penis planter, essentially. He put a bulletin board up listing her as president of the Man Haters Club. And then there's just a whole bunch about that just I could go on and on about that. But he had this list of things that he posted that talked about how sperm has a right to live, and all the great chefs in the world are men, and that prostitution should be legalized, and just stupid stuff. So, and he touched her. He didn't touch her butt, he didn't touch her breast, but he touched her hands, he invaded her space, he just got too close to her. The Eighth Circuit determined that behavior was not severe or pervasive, that it did not constitute sexual harassment. It was not bad enough to be considered something that would alter a person's terms and conditions of employment. So there was another case. It's the Legrand case versus the area, I'm not sure what it was, area something for community and human services. This was a parish priest who was consulting with this nonprofit where this particular individual worked. And the priest invited the plaintiff in to watch pornographic movies with him, and then invited him to engage in sexual activities with him. Again, the court said that wasn't bad enough. That was not severe or pervasive. This is the Eighth Circuit, which we're in. We are in the federal Eighth Circuit. Another case where a male co-worker frequently commented about the plaintiff's body, touched her bangs, touched her hair, would wipe water off her pant leg, would ask her for dates, would suggest that she leave her boyfriend, would, try to give her rides home, talk about her body, et cetera, et cetera. That was not severe or pervasive. Another case, the co-worker would touch the employee's face, would say, "I can make or break you," called her baby doll, called her honey, called her on the phone, said, I want you to be with me. We should be sipping Mai Tais. You're going to be one of my girls, aren't you? The court chalked that up to being ungentlemanly and said it was not severe or pervasive enough to constitute sexual harassment under Title VII. So that was sort of the backdrop of cases that attorneys in the Twin Cities area were dealing with when we had sexual harassment cases. It got to the point where nobody wanted to be in federal court. Nobody wanted to bring cases under federal law. And that's where Kenna came in. And so in the Kenna case, we argued that, and I'm going to jump ahead here a little bit. The Kenna case is listed there in this screen. What we argued is that, societal norms and, attitudes about sexual harassment have changed over the years, and that your average run-of-the-mill person would think that this conduct and these behaviors that were being experienced by women in these cases that the Eighth Circuit said wasn't severe or pervasive would be considered severe or pervasive by any reasonable person. And the Minnesota court essentially agreed with that. The court was not willing and did not eliminate the requirement that plaintiffs who bring sexual harassment claims under the Minnesota Human Rights Act have to show severe or pervasive behavior. But what the court said was that we no longer will compare our Minnesota cases to cases decided under federal law. In the past, what had been happening is that courts in Minnesota were saying, well, yeah, gee, that sounds really terrible, that they had to put up with this person touching them and saying all these disgusting things to them. But boy, when you compare, that to what happened in Duncan and in the LeGrand case and in some of these other cases, it doesn't seem any worse than that. And in those cases, the federal court said that's not sexual harassment. So how can this be sexual harassment? So that was happening time and time and time again. Well, the Minnesota Supreme Court said, no more. We are no longer going to permit our courts to compare the facts of a case with federal precedent, that each case has to be decided on its own merits and based upon its own facts and based upon the totality of the circumstances. And so that was a big deal. And so now, and the court also said, and this was something that was very important also, that sexual harassment cases in Minnesota generally should be decided by a jury and not by a judge. Because what was happening in most cases is that the courts were deciding on summary judgment these cases. And so instead of letting it go to the jury, the judges were saying, well, there's no case here. I'm dismissing it because you can't show that the behavior was severe or pervasive. And so essentially, judges, most of whom were male, were making the determination that these cases were not severe or pervasive and thus did not constitute sexual harassment. And now the Minnesota Supreme Court has said, nope, unless there's something else going on that would, dictate a summary judgment, cases need to go to a jury. So cases need to be decided on their own facts. Cases need to be decided by a jury. So things are starting to change in the state of Minnesota. Things are not changing in the federal courts. So that's just, kind of the lay of the land there. I hope that wasn't too boring, but it is just something I think that everybody needs to know, that things are getting better, but it's still very challenging and difficult to demonstrate sexual harassment under the law because, like I said, not every slight, not every insult, not every hug is going to constitute sexual harassment. So here's something else that we deal with all the time, and this I'm sure you talk to people all the time, and this happens. This just happens to people. You're working with somebody who we call the equal opportunity harasser. So somebody has a coworker or a supervisor who's just a jerk. This person is just a jerk to everybody. Doesn't matter if you're a man, a woman, it doesn't matter if you're disabled, doesn't matter what your religion is, it doesn't matter your race, your national origin. There doesn't seem to be any rhyme or reason. They're just a pill, a pill to everybody. That's not illegal. Okay, it's just not. So I have to tell a lot of people a lot of the time, I am sorry this is happening to you. This is terrible. But basically what you're dealing with is a bully. Bullying in the workplace is not illegal. It's only illegal if the bully is targeting the individual because of their protected status. So because they're, from Somalia, because they're 60 years old, because they're disabled, because they're Black, because they're, whatever that protected status is, if the harasser is targeting that person because of that status, it's illegal. If they're just being a bully on the playground, only now they're adults and they're in the workplace, it's not illegal. The poor employee just has to make a determination about what they're going to do. Are they going to continue to put up with it? Are they going to go find other employment? And certainly, I would urge in every instance to report. One of the reasons it's so important for employees to report what's happening to them, whether it's illegal harassment or not. Employers are only liable for behavior if they know or should have known it's happening. So if a coworker, let's go back to the sexual harassment situation. If you're a coworker, or if your coworker is harassing you, and the boss or management doesn't see it and has no reason to know that this is happening to you, the employer is not going to be liable. They can't be liable for something that they don't know is happening. Now, on the other hand, if the employee reports the harassment, says, you know what, this person has said this, that, and the other thing, they've come up and they've kind of grabbed me, or whatever, they've done some things that need to stop, and the employer doesn't do anything about it, and it keeps happening, and the employee reports it, saying it's still happening, and the employer just doesn't do anything about it, then the employer is liable. So it's really important to tell people, report, and document that you've reported it. Either send a follow-up email or text. Email's better, saying just because it's hard to capture the text with the email. You can print out a copy. With text, you've got to screenshot it, and it's really tough to use that as evidence. So I am an advocate for email or a regular letter or memo, but I mean, who does that anymore? So email would be the best course of action for most people. And so, follow up with the email saying, this will just confirm the conversation we had this morning, during which I told you that so-and-so was doing these things. And I really need you to do something about it, because I'm starting to feel, quite threatened and intimidated, or, it's affecting my ability to, do my work, or, to enjoy my work environment. So that's really important to report. Okay, so I kind of got off track a little bit, but so I jumped ahead is what I did. What the next slide is, what do you do if you're being sexually harassed? And I've already talked about that. Report, and then document your report. So as I said, if the harassment is by a coworker, the employer is only liable if the employer knew what was happening and failed to remedy the situation. Now, it's a different matter if the harassment is by a supervisor. If the harassment results in a tangible employment action, the employer will be strictly liable. So what that means is this: if supervisor, who is deemed a supervisor because he has the authority to hire and fire, is sexually harassing somebody, or harassing the employee for another reason, because of race or national origin or religion or whatever the case may be, and that person ends up being fired, the employer is going to be strictly liable for that. If the harassment does not result in a tangible employment action, the employer will only be strictly liable if, one, it took reasonable steps to prevent the harassment, and two, the employee failed to avail herself of preventative or corrective opportunities. So the bottom line of this sort of analysis, or this rule, is that employers essentially need to be sure to have taken steps to prevent the harassment, which means employers, there's no law that specifically says, employers, you have to have a policy that prohibits sexual harassment, or employers, you have to train your employees about what to do if they've been sexually harassed or harassed for other reasons. There's no law that says they have to do that, but when conducting the analysis about whether an employer is going to be liable for the harassment, one of the things that the courts will look at is, well, what did they do, if anything, to try to prevent the harassment? And if an employer took reasonable steps to prevent the harassment. It had a policy against harassment. It provided training to its employees and to its management. And it made it very clear what an employee needs to do to report harassment. And the employee failed to take any steps whatsoever to try to protect herself or himself, the court's going to say, well, this employer is not liable because there were policies in place, there was training that had happened, and the employee just didn't do anything to try to protect herself in terms of reporting it. So that's, again, I mean, it all goes back to report, and then document your report. So, I mean, I'd say that's one of the biggest takeaways here today is when you're talking to people, if you can get them to report what is happening, that is a big deal. That needs to happen. They need to report. Okay, so I mean, that's sexual harassment. And I just sort of whipped through that pretty quickly. And so if there's any questions, I'm happy to hear them, but I want to move on to some other causes of action. I know that you deal with people who have suffered from domestic violence and sexual assault, outside the workplace and in the workplace. And there are some other avenues that I want to talk about that people can take outside the federal and state sexual harassment laws for trying to redress the harassment or the assault. So if I'm trying to think of an example. So let's say an employee has suffered from sexual harassment by a coworker or a supervisor for that matter. And there is some evidence to suggest that this person is a serial harasser. This person has harassed in past employments, and that this employer should have known that, or has been abusive in past employments. And there's some reason that this employer should have known that. There's the potential to be able to bring a negligent hiring tort action against the employer. That's a little bit tougher because there are not that many circumstances where an employer is required to do that sort of in-depth kind of digging about a new hire. But if there's some reason that an employer should have known that this person had a track record and they still hired that person, there could be the basis for a negligent hiring claim, and that would be a tort claim. So it's not a claim brought under state statute or federal statute. It's a state common law is what it is. So it's a tort. It's a type of cause of action that was developed under case law. So negligent hiring is one avenue. Another avenue is negligent retention. And this is a little bit more, I think, viable because, we all know people who know situations where employers have let the harasser get away with harassing other people. You find out during the discovery, during litigation that, I'll be darned, this is not the first time this has happened. This person complained of harassment. Turns out the harasser has harassed before in the same company, and supervisors, management, they knew about it or had reason to know about it and just sort of swept it under the rug. That gives rise to a negligent retention claim. If this employer did not do something to stop that person, like fire them, for example, and they did it again, there is a potential cause of action. Again, it's a tort. It's a lawsuit that the individual can bring against the employer for negligently retaining that individual in the workplace. A similar cause of action is the negligent supervision claim. This person, the employer had reason to know that this person was dangerous or potentially dangerous, or had harassed people in the past, and for whatever reason they didn't fire this person, and so they should have been on a kind of a higher level of supervision, and they failed to do that. They just ignored this person, let them go about their merry way, and they did it again. The claims that individuals can bring against the perpetrator are limited to an assault and battery claim under state law. So assault under state law is, under state common law, a civil cause of action. A civil assault is different than a criminal assault. So a civil assault is where someone does or says something that makes the plaintiff fearful, the employee fearful. Whereas the battery is the actual touching part. So the assault is not the touching, the battery is the touching. And oftentimes, they go hand in hand. You've had, somebody who's been battered, they've been assaulted by somebody at work, and they've also been assaulted by that person because maybe that person is threatening them or intimidating them in some other way. And so that is what that gives rise to the assault claim. There's a couple issues with that we'll talk about, but in addition to bringing an assault and battery case, or it could be just battery, against the perpetrator, and that would be a state court action against, Joe Blow, who caused the assault in the workplace. It's possible for the employer to also be liable for assault or battery that happened in the workplace, but the conduct has to have occurred within work-related time and space and have been foreseeable. So, for the employer to be liable for assault and battery, it has to have happened, in the workspace and during work time. And it also has to have been foreseeable. That employer has to have had some idea, some knowledge that, could have prevented this from happening. Otherwise, they're just not liable for that assault that happens. The complication comes into play with the Workers' Compensation Act. So, most of you probably know that in Minnesota, injuries that occur in the course and scope of employment are covered by the Workers' Compensation Act. It's a Minnesota state law. It's sometimes, unfortunately, the exclusive remedy. So, a typical situation is where somebody is, they're working on a machine and, slice their hand and get some sort of tendon injury. They file a claim, and their medical bills, and maybe if they have lost time from work, are covered by workers' compensation insurance because they were injured, in the course and scope of their employment, using that machinery or whatever. Assaults in the workplace can also be the exclusive province of the Workers' Compensation Act if the injury was caused for reasons that are not personal to the employee. So let's say it didn't matter who this employee was, this harasser or abuser was going to hurt anyone that he worked with. I mean, the opportunity was there because he was working with people. He came across an employee, and just by virtue of their working in the same space and at the same time, he assaulted her. I'm using that gender just because that's more often than not, the gender. That would be covered by workers' compensation. In order to get it out from underneath the workers' compensation exclusive province, the employee has to be able to show that the injury was for personal reasons and not for work-related reasons. So, that would be, for example, say, two people work together and they were a couple, they had a relationship, and then the relationship ends and one of them assaults the other. The assault is for personal reasons, and so that would not be covered by the Workers' Compensation Act. But if somebody is just at the wrong place at the wrong time in this workspace and happens to get assaulted by somebody in the workplace and they're physically injured, that is a workers' compensation injury. They cannot file a sexual harassment claim. They cannot file a a common law tort claim. Their exclusive remedy is workers' compensation, if it results in that physical injury. So that's something to keep in mind. Some other laws that I wanted to talk about that can relate to individuals who have suffered from harassment and assault in the workplace. There's medical leave that is available for people who have serious health issues. And one of the laws that protects people with serious health issues is the Family Medical Leave Act. But again, as with all federal laws, employers who are covered by the Family Medical Leave Act have to have 50 or more employees during the 20 previous weeks. So if you work for a small mom and pop shop, company that has 10 employees, you don't have the right to family medical leave. You just don't, because that employer is not required to give that employee family medical leave. If your employer does have the requisite 50 or more employees during the 20 previous weeks, and you are an employee who has worked 1,250 hours or more during the 12 months prior to your start of leave, you're eligible for family medical leave. And what you're eligible for is up to 12 weeks leave per year to take care of yourself or to take care of a spouse, a child, or a parent with a serious medical condition. Now, one thing that people don't always understand is that family medical leave does not need to be paid. Some employers do pay for family medical leave, but it's not required by federal law. However, again, Minnesota, yay Minnesota. Beginning January 1, 2026, Minnesota employees will be able to take up to 12 weeks paid leave. So, we again are ahead of the curve, but that doesn't start until 2026. So we've got a ways to go. The law is a little complicated and it's not, it hasn't been tested yet because it hasn't taken effect yet. But essentially what the law currently says is that the legislation says is that, you can take up to 12 weeks paid leave, but you can take up to 20 weeks if you have more than one qualifying event. So let's say you had a serious illness that required you to use up your 12 weeks, and now now you're pregnant, and you need more time in connection with that separate qualifying event. Minnesota law will allow you up to 20 weeks. You have to have earned $3,500 in the prior 12 months in order to be eligible for that leave. And employees have to have applied for leave 30 days in advance of the leave. And then also the premiums, the coverage, it's some sort of, and I'm not even sure completely how this all works yet, but there's a shared, essentially, insurance policy or something that will cover the wages. I mean, it's not even an insurance policy. It's the state of Minnesota, and the employee and the employer will share in the responsibility for basically paying into this fund that will provide the wages for the individual who is on leave. And again, I'm not completely familiar with the program yet because it's just brand new, but I don't think employees will get their full wages necessarily, but they'll get some of their wages, maybe up to 2/3 or something like that. And the employee and the employer will each pay a portion of the cost to fund that program, and the premium will be deducted from wages. So again, I'm not quite sure how that all works, but it's something for us to keep our eyes on. It will go into effect in 2026 in January, and it'll be interesting to see how that all shakes out. But it's a good thing. It's a good thing that employees will be able to get at least some of their leave paid, because right now, if you're eligible for family medical leave, your employer does not have to pay you for that time off. At least you get the time off, and you can't be fired for taking the time off, but you don't get paid. So, all right. What I can't see my heading here. There's something that's cut off, but oh, what if an employee exhausts their, I think it says something like it has exhausted their leave under the FMLA and does not return to work? They can be fired. So, an employee takes 12 weeks leave, and I don't know if my slides say it. I don't recall if I put it in there, but leave doesn't have to be taken all at once under the FMLA. You could take 2 weeks here, you could take a week there, you could take 6 weeks there, or it could be even more intermittent. Some people have intermittent FMLA leave where maybe they have they suffer from terrible migraines, and they may need to use their FMLA leave, 1 day a month, let's say. That's called intermittent leave, and that's permitted under the law. I mean, it's even, if you have a child or parent who has a serious illness and you just need to leave work an hour early, 3 days a week to get your parent to their care provider, you can do that under the FMLA. You can take that intermittent leave, that 1 hour, you can leave 1 hour from work early, 3 days a week to accomplish that goal. So that's what intermittent leave is, and it's permitted under the law, or you can take it all in one fell swoop. But what happens if you've used it all up? So you've got 12 weeks leave, you used it however you needed to, and now it's gone, and you don't have any more leave that year. Well, if you don't come back to work, you can be fired. And it won't be considered retaliatory because the expectation is that you will return to work after your FMLA leave is over. However, depending upon your circumstances, an employee may be entitled to additional leave as a reasonable accommodation under the ADA or the MHRA, the Minnesota Human Rights Act, and the ADA, the Americans with Disabilities Act. So, and I've had many clients with a situation where, my leave is coming up, or my FMLA leave is almost up. My employer is saying, your leave is going to be up next month. We expect you to return to work on such and such a date. Please confirm that you're going to be returning. And my client says, I can't come back. My doctor's telling me I need another month. I need another month to recuperate. I need another month to, have some more therapy, whatever the case may be, that, another month and I should be good to go, but I still need another month. So what that employee may be entitled to, depending upon their condition, so long as their condition rises to the level of a disability under the law, that individual may be qualified for additional leave as an accommodation under the ADA. So the Americans with Disabilities Act and the Minnesota Human Rights Act requires employers give individuals who are disabled, who meet the definition of disability under the law, and who are qualified, to perform the functions of their job, a reasonable accommodation that will allow them to perform the functions of that job. And so let's just kind of break that down a little bit more. So who is disabled under the ADA? That would be somebody who has a substantial impairment that limits one or more major life activities, or one who has a record of disability, or one who is regarded as disabled. The one I'm going to talk about is the first one who has a substantial impairment that limits one or more major life activities. So that covers a lot of things. And thank goodness for the Americans with Disabilities Act, Amendments Act of 2008, because now things like mental health are, considered to be substantial impairment that can limit one or more major activities. So let's say you have, a mental health issue that prevents you from or impairs your ability to concentrate. That is probably going to be considered a disability under the law. Additional major life activities, some of the basics and the most obvious are things like seeing, walking, lifting, bending, sleeping, speaking. But now, thanks to the Amendments Act of 2008, any condition that is systemic, your endocrine system, your lymphatic system, your psychological, mental well-being, your musculoskeletal, all of those systems, if something's not working, that's considered a disability under the law because it's going to affect a major life activity. Maybe your kidneys are impaired and it affects your ability to, I don't know, I can't think of what, you have to be on dialysis or, something like that. That is a disability under the law. And so if you have a disability under the law and you need to have additional time away from work to recover or rehabilitate or whatever the case may be, and you've exhausted your family medical leave or any other leave for that matter, if you might have leave through your employer's program, they might have some leave that they're not required to have by law, but that they just do. If you need more leave, you may be eligible to request a reasonable accommodation. Now, employers oftentimes will say, well, if you need, 6 more months leave, that's not reasonable. We need somebody here. We need somebody in your position to do your job, and we can't hold your position open for 6 months. More often than not, the courts will say, yeah, that's reasonable. It's reasonable that it's not reasonable. It's not a reasonable accommodation. No employer should have to hold the position open for 6 months for the employee to get well and come back. There are exceptions to that, and there are cases when it is reasonable for the employer to do that. They can hire a temporary worker, person can come in, can hold the job down for a couple of months, whatever the case may be, and it would be a reasonable accommodation. But the longer the leave required, the more tenuous it's going to be for the court ultimately to say, yeah, that was a reasonable accommodation. All right, so what other accommodations? This is just about accommodations. Okay, so what accommodations must an employer provide? Only those that are reasonable. This is important. Employees oftentimes, will say, well, I said I would like this accommodation or this accommodation, and they've offered me a different accommodation. Employees don't get to dictate what the accommodation is. I mean, there are circumstances where some individuals have to have a certain accommodation because of their particular situation. But if there are, a couple of different accommodations that could accommodate the goal of getting the person back to work, or allowing the person to perform the essential functions of their job, the employee can't say, well, I don't like A and B, I'll pick C. The employee can say, well, I'd rather have C, but if the employer says, well, we'd rather do A and B, and those both look like they'll work, so we're going to do that. That's how it goes. The employee doesn't get to dictate which of the reasonable accommodations will be provided if one, will do just as well as the other. The accommodation must be in place for the purpose of enabling the employee to perform the essential functions of the job. So a good example of that is, with respect to like computer assisted devices, for example. If somebody's seeing impaired, there are programs that allow the individual to better see their screen. Maybe they have to do a lot of computer work, database work, or whatever the case may be. If there are assistive devices that will allow the individual to do that work, that is an accommodation that allows the employee to perform the essential functions of their job. Sometimes employees are so disabled that there is no accommodation that will allow them to perform the essential functions of the job. If they're, sometimes somebody is so impacted by their mental health disorder, for example, or disorders, that they're just not able to come back to work. The employer doesn't have to hold the job open indefinitely, and if the employee, if there's not any likelihood that that employee is going to come back to work anytime soon, the employer doesn't have to hold the job open. And so I do talk to people, from time to time who want to hang on to their job and who say they just need an accommodation, but when it gets right down to it, there is really nothing that that employer can do that will allow that person to do the job. And essential functions, I just want to stay on that point for just a minute. It's the accommodation has to allow the employee to perform the essential functions of the job. So the employer cannot say to an employee, well, we have, your job involves 20 different functions, and this one function you perform once a year. And there's other people who can perform that function, but you can't perform that function even if we provide you accommodations, and so we're just not going to be able to have you come back to work. That's because that one function sounds like it's not an essential function. If other employees can perform it, if there's other people available to perform it, if it's something that is only performed once in a while, it's not an essential function. So keep that in mind. What else? These are just some miscellaneous laws. There's a whole bunch of them, but I picked out a couple that I thought might be useful. In Minnesota, employees have the right to review once a year their personnel file. So if the individual is still employed at the company or wherever they work, and wants to see their personnel file, they have every right to do that. They just can't go in every other week or every other month. It's only once a year. Now, once an employee has been terminated or resigned their employment, they have the right to request a copy of their personnel file. So and in a related law is that employees have the right to know, have the right to a truthful statement about the reason they were terminated. And so I tell people fairly regularly, if they've been let go, to make a written request for a written explanation for their termination, and also for a copy of their personnel file. The personnel file has to be provided within 7 days of the date of the request if the file is located in Minnesota. If it's out of state, the employer has to provide it within 14 days. And the request for a written truthful explanation for the reason they were terminated has to be made in writing also, but that has to be made within 15 working days of the termination. So, and that happens where people say, oh gosh, I was terminated 6 months ago, and can I get a truthful reason for my termination? And I always tell them, go ahead and make the request. You have to make it in writing, but technically, if you don't make the request within 15 days of the date of the termination, the employer doesn't have to give that to you. But there's no harm in asking, maybe they will. So that I think can be useful for employees, because oftentimes they'll see what's in their personnel file, and there might be things in there that they don't even know about. And maybe they get a better picture of whether they have a basis for a lawsuit or not. So that can be useful. And then also having the written explanation for the termination is I have found extremely useful, because it is not unusual for an employee to be told one thing verbally, well, we're terminating you because of X, and then they get a written statement that says something completely different, and that, you know, tends to beg the question, well, which is true, and why is this employer making things up? You know, maybe the real reason is something more nefarious. Maybe the real reason is you know, there's some discrimination or retaliation afoot. So what else? Whistleblower protections. So more laws that are useful to know. Minnesota statute 181.932 makes it illegal for an employer to terminate or discipline or threaten or discriminate against an employee who makes a good faith report of a violation, suspected violation, or planned violation of a federal or state law or common law or regulation. It has to be a rule promulgated by law or a law, whether it's a statutory law or a common law, you know, a case developed law. It has to be something that's law. It has to be a good faith report. The employee has to be saying, you know, maybe I'm not sure this is happening, but I think it's happening. I think my employer is violating the law. Here's what I think is happening. That's a good faith report. And if you're fired for it, you've got a cause of action. Oftentimes, employees will think they are whistleblowers because they reported a violation of policy. An employer has a policy, a written policy that was violated. Policy is not law. Policy is not state or federal regulation. Policy is not even really enforceable. Policy is great to have because it sort of sets a guideline or a framework for how you should expect your employer to behave, and how employees, you know, are given guidance how they're supposed to behave. But when it comes right down to it, it's really difficult to make a contract out of a policy, because that's what you'd have to do to be able to enforce a policy under law. So, you know, we've all tried it. We keep trying to get the courts to say, well, that was a policy. It was in their handbook, and, you know, they should be held to that standard. And the courts just keep saying, no, it's not a contract. It's not a contract. Unless you have a bona fide contract, you don't have a breach of contract when the employer fails to follow its own policies, generally speaking. So, all right. Statutes of limitations. This is very important. I want to make sure I'm not getting crossways or, you know, running out of time here. Under federal law, if an employee's been discriminated against or retaliated against, that employee, before they can file a lawsuit under federal law, they have to, as a prerequisite to filing a lawsuit, they have to first file a charge of discrimination with the Equal Employment Opportunity Commission. We have an office in Minneapolis. I can't say enough about how that is absolutely a prerequisite. It's a requirement. Now, employees do not have to first file a charge in order to pursue a lawsuit under state law. They can file a charge, and the filing of the charge will toll the statute of limitations, but they don't have to. But just to be on the safe side, I usually tell people to go ahead and file the charge, because, you know, they may want the option of filing a claim under federal law. You know, ultimately they may decide not to, but just to be on the safe side, file that charge. It gives them that you know, the right to do so. To file a charge under federal law, to file the charge with the EEOC, it has to be done within 300 days of the adverse employment action. So if the adverse employment action is, I was terminated because I reported harassment, what date were they terminated? The 300 days starts to run from that date. That is the date that they were essentially discriminated against or retaliated against. Retaliation is just a form of discrimination. So the discrimination occurred the date they were terminated. They were also harassed and reported that harassment. So they could have a separate claim or a co-claim involving the damage they suffered as a result of the harassment too, not just the damages from the termination, but the damages from the harassment. And the statute of limitations with respect to harassment is a little different. There's not necessarily a discrete date by which or on which the harassment took place. It usually, by definition, for harassment to be harassment, illegal harassment under the law, it has to have been either severe, so there could be one like super severe assault, for example, event, or it's pervasive. So it's something that happens over a period of time. When it happens over a period of time, we call that a continuing violation. And so let's say the harassment started in December of 2022, and it continued until July of 2023. The statute of limitations for purposes of filing a charge of discrimination under federal law would be 300 days from that last date, from that February 20, or what did I say, July 2023 date. So that gets a little complicated, but harassment law is viewed through the lens of a continuing violation, because usually it's stuff that's happened over a period of time, whereas discrete discrimination happens on certain dates. So I was, given a letter of reprimand on this date. All right, your 300 days starts from that date. I was terminated on this date. All right, your 300 days starts on that date. I was denied a promotion on this date. That's when your 300 days starts to run. So keep that in mind. Under state law, to bring a claim under state law, under the Minnesota Human Rights Act, employees, again, aren't required to first file a charge, but they can. So they either have to file a charge or a lawsuit within 365 days of the adverse employment action. And if these dates aren't met, the 365 under state law and the 300 under federal law, the employee will forever lose their right to bring a claim under either federal or state discrimination laws. To bring one of those claims that I was talking about, the negligent retention, negligent supervision, those sorts of tort claims, assault and battery, that's a 6-year statute of limitations, and so that's a lot longer, obviously. The workers' compensation statutes of limitations are kind of weird. So employees have to give notice of their injury to the employer, and then the employer is obligated to file what's called a report of injury with the state. So if the employer does what they're supposed to do and files a report of injury, the employee has 3 years from that date to file their workers' compensation claim. If the employer doesn't do what the law tells them to do, that is file the report of injury with the state, then the employee has 6 years to file their claim of workers' compensation. And the workers' compensation process, the claims, the benefits, that's all handled through the state of Minnesota Office of Administrative Hearings. There are administrative judges, and there's just a whole body of personnel dealing with workers' compensation cases. There are workers' compensation lawyers. It's a very highly specialized field. So I, for example, wouldn't take a workers' compensation case. It's just so super specialized. Likewise, most workers' compensation lawyers wouldn't take an employment case. Some do, but maybe they shouldn't. So it's, sometimes you'll have to give some thought to whether, if there was an injury on the job, to maybe suggesting that employee contact a workers' compensation attorney. They may need a workers' compensation attorney and an employment attorney. So just kind of think about that. Physical injury on the job is the trigger for you to think about whether or not they might have a Workers' Compensation Act I'm sorry, a workers' compensation claim, and it may or may not be the exclusive remedy, but you know, if there's an injury, a physical injury on the job, you know, that's what should trigger for you. Hey, wait a minute, maybe this person needs a workers' compensation lawyer. And so, you know, keep that in mind. And then, all right, well, now I have come to my blank slate here of questions and answers, and then there's my contact information. So does anybody have any questions? I haven't heard any so far. I thought maybe I'd be interrupted, but I haven't been.
I didn't see any, Kelly, so
Okay.
I think we're good.
All right, no questions, and I think we're good on time too. I hope I haven't kept anybody too long. All right, well, good. Well, I hope that this has been helpful.
Yeah, thank you so much. Very good information.
All right,
And thank you everybody for joining us today. We'll see you again next month.
thank you, everybody. Bye-bye.
Bye.